On to this story now. The public protector is having a difficult time proving her worth in office. This follows yet another ruling against her after the report on the SARS rogue unit was set aside by the High Court. This comes at a time Parliament is looking into her fitness to hold office. However, Mkhwebane isn't taking that lying down, as she will consider all options to challenge the decision. Freedom Under Law's Nicole Fritz joins me to discuss this. Thank you very much, Ms. Fritz, for your time here on ENCA. Of course, that court finding yesterday also saying that she was biased against the now Minister of Public Enterprises, Pravin Gordhan, saying that, when she said that Gordhan lied about that Ambani meeting with the Gupta associates. She looks as though right now, she is part of a certain faction of the ruling party.
Well, it's certainly hard to imagine a more damning judgment in respect to the public protector than the one delivered by the Gauteng High Court yesterday in respect of this report. A report that made negative findings not only in respect of Minister Gordhan, but also in respect of former SARS employees, Opa Magashula and Ivan Pillay. And yes, I mean, there are a number of flaws that the judgment, the court holds have been perpetrated by the public protector. But I think most damning that she has failed to adhere to the key tenets of justice and fairness, which is to hold an open and honest mind in shifting the evidence that was put before her in coming to conclusions, that she, as you've already indicated, applied a biased mind, brought a biased mind to bear in making her determinations. And that is amongst, I think, the most serious charges and conclusions that can be leveled against a person who occupies as serious, as grave an office as Ms. Mkhwebane does in respect to the Public Protector's Office.
This is not the first time the Public Protector has had such a damning report against her, with costs included as well by the High Courts. She has other cases, and now Parliament is also discussing whether or not she's still fit to hold that office. She really is bringing that Public Protector's Office into disrepute and having the public not trust it.
I think that that's right. As you've indicated, this is not the first such damning report. There have been several, and there is a process underway to look at removing her from her office. I think for the public, it is a real tragedy, because it is not as if the mandate that she has as incumbent in that office is not an incredibly important one, that we know that there are huge costs to corruption within the public service, that we need an occupant of that office who uses her powers to investigate and to draft remedial action, which can really take us forward in meeting the challenge of corruption and securing redress for that, so that our public service is free of that kind of abuse and maladministration. But unfortunately, certainly as the judgment of yesterday shows, we do not have such an incumbent in office.
And of course, the public now, for instance, comparing her to her predecessor is also something that is also not really fair on her, but understandable, coming from the things that we found from the previous public protector.
Right. I mean, I think, probably sort of a comparison with a single person is not necessarily fair. I mean, every incumbent of the Public Protector's Office is going to be different. So I don't think that, that's necessarily the standard as against Ms. Madonsela's performance. I think what's interesting is if you look at the judgment of yesterday, right, is that they say, I mean, in one part of the judgment that Ms. Mkhwebane, in fact, is dishonest in respect of a judge. She says that a judge, in making an adverse finding against Ms. Mkhwebane, has deliberately omitted certain words from the statute. And if you look at certain words from the statute, from the Executive Ethics Code, if you look at the Executive Ethics Code, it's plain that Ms. Mkhwebane is wrong, that she is accusing the judge falsely, that it is she that has misread that section wrongly when she makes the adverse finding against Pravin Gordhan. And the court there is so astonished by the behavior of Ms. Mkhwebane, that they say, she's not just the public protector, she's an officer of the court as an advocate. She owes a duty and obligation to the processes, to the integrity of the courts, and that she has not played her part. She has not done what is required. And they say that she must apologize to the judge. Not only must she apologize, but that a copy of the judgment must be sent to the Legal Practice Council so that they can consider taking action against Ms. Mkhwebane, not so much just in her position as public protector, but in her position as an advocate and the duties that she is required to uphold as an officer of the court. Now, that's a very astonishing finding to make by a court in respect to the public protector, saying she's not only failing to fulfill her duties and requirements as the public protector, but she's failing to fulfill her duties and obligations as an advocate, as an officer of the court.
Very scary to think that the public protector, it's not the first time that a high court has found that she's misread the law. As a public protector, that is terrible to think of, and as an advocate, it's also just something that we baffle with, because she's supposed to understand the law and not misinterpret it. But let's talk a little bit, if you don't mind, Ms. Fritz, about the High Court in Pietermaritzburg today hearing that case. Well, we know that it's going to be postponed, of Talis trying to get the state to withdraw that racketeering charge. It's been quite a long time with this case going back and forth in court with all of these delays. Very unfair, not only for people wanting to know what happened, but even for President Jacob Zuma, the former president, as the accused.
It is very unfortunate that the delays are such that it has taken this amount of time. We know, there are the aphorisms, justice delayed is justice denied. Obviously, every due process needs to be observed, but particularly with a case of this nature involving the personalities that it does, having the importance that it does to our legal system and our ability to see how the courts and the legal processes treat accused, whatever rank they hold. I think it is most unfortunate that we continue to see these delays.
Now, of course, looking at the fact that this has been a case, like we were discussing, that has gone on for so long, but there's also, the former president as well as Talis themselves have every right to explore every avenue, and even though we'll look at it as something that is being used as a delay tactic, they have every right to explore every avenue in this case.
Well, I think that is true, provided that there are legally sound reasons and rationales. Due process must be observed in every respect, and we can't then talk of a legal system that is, treats those who are implicated by it freely and fairly and without prejudice if those due process protections are not observed. We're seeing here a fairly technical process, the delay being occasioned by the fact that Talis has applied to have the racketeering charges against it withdrawn. There has been no judgment yet in respect to that application, and that is the result of this delay. And certainly, for the ordinary person in the street, I think these kind of, very technical interlocutory proceedings can be hard to understand, and it can be hard to appreciate the delays.
Well, thank you very much for your time. That is Freedom Under Law's Nicole Fritz coming to us live here on ENCA.